This is Frank Sawicki with Family Promise of Sussex County. Here today, you are joining us for STEPP, that is Stabilizing Tenancy Eviction Prevention Program. So again, thank you very much for joining us this evening. We have a really great course here for you tonight. Moving into our lecture for this evening. So again, welcome aboard to Course 2 of Stabilizing Tenancy Eviction Prevention Program, or STEPP. So again, this is not a dance class. This is a landlord-tenant law lecture series. So just to give you a little bit about what we're doing this evening's course is what we are calling Familiarizing Yourself with the Law. So this is dedicated to those defendant tenants who find themselves in the eviction process. You are in landlord-tenant court being sued for eviction, and you, like many of the tenants that I come across in my experience, we find that you might not be able to afford an attorney. You might not be able to um, be able to have the money, the funding, because if especially in those cases where it's non-payment of rent, which is what we commonly see at Family Promise of Sussex County. In those instances, if you can't pay your rent, it's going to also be difficult to afford a private attorney. So this course is dedicated to knowing the law, not only, not just knowing the substantive law, which again, this is not a law school course, so it's not designed to provide you with every nuanced bit of law, although we do have series that are dedicated to understanding what the eviction process is going to be like, and helpful tools and tidbits that are going to be able to help you resolve and rectify your circumstances. This more tonight, again, familiarizing yourself with the law, is understanding when you need a lawyer, how to obtain certain legal services, low cost or free pro bono services, what you can do when you represent yourself, what kind of resources are available to you, and the different, just different things that are out there to assist you in the event that you find yourself, again, being evicted in landlord-tenant court, and you are in need of resources and you need the assistance. So that's what we're going to do tonight. We're going to cover that topic. So again, I just want to tell you a little bit briefly about what we do here at Family Promise of Sussex County. We are a nonprofit charitable organization that is devoted to helping people who are struggling with their housing issues. And reiterate, this is a service that is here. It's a series. So this is course 2 in a 10-course series. We're doing Familiarizing Yourself with the Law. This is devoted to helping people who need how to access like legal services and how to take advantage of the resources that are available to you to help you with your case. And then, this is again part of a series of courses. Last week, we kicked off our first class with housing discrimination and what that looks like, your experience when you are searching for housing, and what discrimination looks like in all of its forms, and the different legislation that protects you against discrimination, and the things you can do to either protect yourself, or in the event that you do find yourself being discriminated against, what you can do legally to rectify those circumstances. So today, and then going forward, we've got some other wonderful courses lined up that are going to be really excellent. So we've got course 3 is going to be so every course is going to be Tuesday evening, with the exception of the week of Columbus Day. So every Tuesday at 5:30, we are doing a different nuanced topic in landlord-tenant law. So course 3 is going to be renting your new home and understanding your lease. Course 4, we're doing rent increases. Course 5, we're doing habitability. Course 6, we're doing lease termination. Course 7, we're doing eviction specific to landlords. We're doing property retrieval post-eviction. Course 8, 9 is rooms, boarding houses, and mobile homes. And then 10, we are capping off with local resources and special programs. So, and each of them are all going to have a guest speaker. We're really excited about the different guest speakers who are going to be joining us for this wonderful class. So again, STEPP, excellent program. It's designed, just go back real quick. to our title page, but you already know it's course two. But again, this is really going to be an excellent opportunity for clients, prospective clients, legal practitioners, area service providers, landlords, tenants, anybody who wants to be part of solving this problem. As you know, in Sussex County alone, where we are based and headquartered, we have seen in the last year 137% rise in homelessness. Landlord tenant issues are, crowding up the dockets. There is just a widespread issue with, potential homelessness, with street level homelessness, the cost of living in this state, wages stagnating. So a whole lot of issues that are going on. But we feel that this will be a really great informational opportunity to provide anybody who's willing to listen and learn, so that you are more aware of your rights. You can assert those rights. And then, of course, it's for landlords, it's for tenants, so that we can have more peaceable transactions, so that we can have less litigious communities, so that people are able to be aware of their rights, and they're not, treading on other people's rights. And that, again, we can go forward and have these transactions that are more informed, less litigious. But of course, in the event that they do become litigated, that you are aware of your rights, you're aware of the resources that are available to you, and you can better understand the process as you go through it. So a better informed, and peaceable civil community. And that's what we're trying to promote here. And this is part of a grant opportunity that was awarded to us by the New Jersey State Bar Foundation. So we're very grateful to them, and we thank them for this opportunity. And we're really lucky, and we're happy to move forward. So again, tonight, course two, familiarizing yourself with the law. So before we get into it, just want to briefly, it's very important we discuss the disclaimer. Family Promise is not a legal service. We do not provide legal services. We are a 501c3 nonprofit charitable organization. We are centered on housing issues. So we help people who are struggling with their housing, whether they are street level homeless, whether they are, about to be homeless because of an eviction issue. We have some prevention programs that help with that. We have rehousing programs. The whole idea behind us is we are housing first. We are housing centered, housing focused. We are social workers, but we will help connect you to those legal services. So just letting you know and making you aware that we do not provide legal counsel. We do not provide legal rights, or excuse me, legal services or legal advice. So if you have any questions, because we will reserve some time for a live Q&A, if you do have any questions at the conclusion of our presentation that regard anything of legal consequence, or any specific advice that regards your case, we are going to defer to the advice of a legal professional, or we will refer you to legal counsel. And we have some services that we will be happy to provide to you as we move forward. So as we move into it, again, I just wanted to, here's the timeline that I was referring to with the different topics that we talked about. And I think I covered that. Again, we started September 10th. And it goes through November 19th. And we have all kinds of really wonderful topics that we're going to discuss that all deal with landlord-tenant matters. Without further ado, let's get into today's speakers. We covered the topics, and today's the speaker. I, of course, am returning as your host, Frank Sawicki. I am the programs manager at Family Promise of Sussex County. And I have with me today, I am honored to be joined by Christopher Witten, who is the Court Services Officer at the Morris County Superior Courthouse. Chris and I've known each other for since I started working at Family Promise. I started here in the spring of 2023 as a resource navigator for our comprehensive eviction defense and diversion program. That program allowed me and another staffer to go as a grant from the Department of Community Affairs. It's a prevention program. It's CEDD for short. We went to court. We represented, we would go and meet with attorneys and court staff and landlords, tenants, and we would try to find alternative resolutions to the problem, whether that was relocation services, if we needed to pay the arrears. But the whole point was to bridge the gap between the courtroom and the area services. So we were there to help literally, navigate the resources in the area and help connect folks to the applicable services. So that was my role when I started here, and my knowledge of landlord-tenant law and experience in the courtroom has grown. And so I wanted to share that knowledge in this series with you and the New Jersey State Bar Foundation, we're so grateful that they were able to help make this a reality. So now it's become a lecture series. And again, I'm joined by Mr. Witten, who is here today, and he's going to tell you a little bit about what he does at the courthouse.
Thank you, Frank, and thanks for having me tonight. Like Frank said, my name is Chris. I work at the Morris County Superior Court in the Civil Division. More specifically, I'm currently in the Law Division, which is mostly monetary lawsuits. However, I started out my first 2 years specifically as the calendar coordinator for the landlord-tenant division, and I continue to assist and do mediations. Prior to my time at the court, I worked at the New Jersey Department of Labor in the Division of Wage and Hour.
Excellent, excellent. And can you tell us a little bit about what you do now? Can you tell us a little bit about that? How's that different from what you were doing in landlord tenant?
Right. So, I mean, landlord tenant is a very specific area of the law. Really, the only question in our cases is whether or not the tenant is going to maintain possession of the property or whether the landlord will take it. What I'm doing now is slightly more complex legal issues. It ranges anywhere from medical malpractice to auto negligence cases, defamation, whistleblower cases, basically anything civil other than landlord tenant or small claims.
Gotcha. And so, did you mention before? I know we had talked about it prior, but if you want to share with folks, you haven't already, of course, what the dollar amounts are involved here, because like in special civil part, you've got small claims, you got district court, and it's very nominal amounts comparatively. Kind of what kind of cases monetarily are you dealing with where you are now in the law division?
Right. So law division is basically any case $20,000 or above. There really is no cap to that. So it could be multi-million-dollar cases. It could be a $20,000 case. Just anything above 20. So, like you said, small claims are as anywhere from $0 to $5,000. The DC docket, district court, is anywhere between 5 and 20, and then law division takes anything in excess of 20.
Wow. So even up to multi-million-dollar cases.
Yeah, we do handle some complex business litigation cases. I've seen cases upwards of $15-20 million.
Wow, that's incredible. That's pretty neat. Okay, very good. All right, so as we move forward with the material for today's court, and I think that's just absolutely fascinating. So again, thank you very much, Chris, for taking the time out of your day. Came all the way up from Morristown to join us up here in Newton. So we're so grateful. We're so thankful for you coming here, representing the Morris County Superior Court and representing Vicinage 10, which is Sussex and Morris County, and being part of this program series. So we're very, very thankful. So thank you once more for your attention to this and the amount of information you're able to provide to our attendees and our viewers. So thank you. So let's just jump right into the substantive material. So, we want to make sure that you are aware of the first subject matter that's important here is, when do you need a lawyer, right? So if we're talking about familiarizing yourself with the law, we're talking about first of all, identifying in those situations when you actually need legal representation. My argument is that, or at least my thought is, and again, I'm not a lawyer, but anytime that you have a situation where you are unclear of the circumstances, or if your landlord is communicating some dissatisfaction with your tenancy, if there's a rule or regulation in the lease that you might have broken, if you are habitually late with your rent payments, certainly if they're communicating that dissatisfaction with you, I'd imagine that it's certainly an appropriate time to start considering legal counsel, or start looking into some applicable laws, or just start safeguarding yourself with some available resources. As I've mentioned in our series already, the through line, or the gravamen that I'm trying to communicate, is that early intervention is key, right? The sooner you can get involved with legal counsel, the sooner you can get representation, the sooner you can communicate with your landlord about an issue that you're having, the better, and the better opportunity you'll have to rectify any circumstances before it becomes too late. But before we get into talking about when you would absolutely need a lawyer, and again, I would say as soon as you start receiving any kind of documentation from your landlord as a tenant, if you're starting to see anything that represents like what's called a notice to cease. So if you've broken some rule, if there's been like you've been charged with like disorderly breaking of rules or regulations of the lease, you have a habitual late payment of your rent, and you see a letter that's either drafted by your landlord themselves or your landlord's attorney, and it says, stop this behavior or you're going to be evicted. But if you do stop it, we won't evict you. But that's a good time, right even then, to maybe seek legal counsel to get some kind of advice. But before we get into that, first off, I just would like to bring to everyone's attention the Legal Services of New Jersey's Landlord-Tenant Manual. So when we're talking about familiarizing yourself with the law, we're talking about in those instances where you're not able to afford an attorney. And we'll talk about some services that are available that Chris has seen in the courthouse that are, a bit more, that are free or very low cost because as I've seen, and as I mentioned before, if you find yourself in a situation where you're being sued for instance, non-payment of rent, it's obviously going to be difficult to afford a private attorney. So making sure that you have these resources available to you. So if you can't afford an attorney and you're not able to retain counsel through legal services, their manual is excellent. So if you Google the LSNJ Landlord Tenant Manual, the first page that's going to come. So literally Google LSNJ for Legal Services of New Jersey, LSNJ Landlord Tenant Manual. The first page that is going to display is tenants' rights in New Jersey. If you click on that, it's going to be a PDF, and it's going to be, again, the tenants' rights in New Jersey. It's the Legal Services of New Jersey Landlord-Tenant Law Manual, and it is exceptional. It is, cover to cover, just going to give you a rundown of the laws, the procedures, the customs, the practices, and the regulations governing landlord-tenant law in the state of New Jersey. And in fact, it is probably the most common and most important reference material used for us in this course. So I refer to it all the time. I did all the time in my experience as a CEBD resource navigator. And I refer to it now, and I'm sure a lot of attorneys use it as a springboard. It is important to remember, though, that it is not binding, legal, admissible authority. So you can't cite the manual itself, like if you do find yourself in court. But it is a great springboard to connect you to that case law, to connect you to those statutes, to connect you to those ordinances or the regulations and stuff like that. And we'll get into, all of that good stuff as well. But what it certainly can do is, like I said, provide you that springboard and those necessary resources. And for landlords, there's information that's great in there that can help you avoid litigation, and it can help you, practice the proper procedures and do the right thing. So it'll help you in avoiding illegal lockouts or doing anything that could infringe upon the rights of your tenants. And of course, again, tenants, it can certainly help you with your interactions with your landlord. It can help you avoid litigation. But if you find yourself in the event that you are in litigation, it can certainly help you with interactions with attorneys as you go through trial and any court and any, go through your case and things like that. It can certainly prepare you and help you to navigate those difficult situations. So why don't we talk about if in the event you do need legal representation, because we can certainly identify the situation when you need a lawyer, right? And I think when you start receiving notices and it starts getting that serious, that it's probably time to start considering that. I wanted to ask you, Chris, how often do tenant defendants actually have legal counsel?
So there's a pretty big disparity between the number of landlords and the number of tenants that we see with representation. Um, Putting a percentage on it would be difficult. I would say probably around 10%, maybe less, of tenants end up with legal counsel. Quite a few of those end up picking up legal services maybe the day of their court date. So we really don't see a lot of tenants walking in with private counsel.
Okay.
Partially because of something you already alluded to. If you're being evicted for non-payment of rent, it's difficult to find and hire an attorney. Attorneys are expensive.
Right. Yeah.
Yeah. So legal services is probably the main source that we see for
Okay.
tenants in
Excellent.
terms of gaining representation.
Okay, absolutely. So on that, before we get into the bits about legal services, like talk about if you don't mind, like from your experience, what you've seen as a court officer. What do you see like versus okay, so tenant defendants typically don't have private attorneys. They usually have to refer to legal services, who are exceptional attorneys, so well versed in the law and so compassionate and just really excellent resource to use. But what is it like on the other end when, with landlords? What's kind of like, if you can, I know you only can give like a rough approximation, but what's the side like for them? Like, what's their representation like?
So, I mean, a lot of landlords' attorneys make a living doing that specific area or practicing in that specific area of the law. We do see a lot of the same attorneys week in and week out. They just like legal services does typically know what they're doing.
Hmm.
They give good representation and they advocate well for their clients.
Yeah. Okay. Excellent. Okay. But you do absolutely see kind of a disparity, like between those who the defendant tenants versus the plaintiff landlords. How does that disparity affect like the outcome of the case? Do you see that it kind of typically goes more in favor one way than the other?
Yeah, I mean, still about probably 98% of our cases settle before they go to trial.
Oh, okay.
It's a very high number. We see very few trials because, like I said, the legal issues are pretty cut and dry.
Yeah.
A vast majority of our cases are non-payment of rent, where the only question is back rent due?
Right.
And so a lot of those cases don't make it to trial. They're either settled where the tenant may come up with a payment plan that's acceptable to the landlord, or the tenant agrees to vacate. So in that sense, still we see a lot of cases settled, but the cases that do go to trial, um, and really one of the bigger advantages I think of having legal counsel is not only knowing the substantive law, but procedurally
Mhm.
how things work. I think that's where a lot of tenants who are representing themselves end up getting tripped up.
Yeah.
If you, and through no fault of their own,
Right.
obviously, if you've never been in a civil proceeding, you wouldn't know
There's
how
a
it
lot of
works.
rules. There's a
There's
lot
a
of
lot of
rules.
rules, a lot of red tape. Trying to do something like cross-examine a witness even
Right. Oh my
can
God.
be
Yeah, I
pretty
didn't even think
difficult.
about that. So like evidentiary rules and things like that.
Yeah, exactly.
Wow.
So it's not only substantive law where representation is helpful, but also procedurally.
So I
Assuming
mean,
you see the
right,
inside of a courtroom and
right.
you don't end up set.
Yeah. So I mean, and again, most people aren't, well versed on that. And I'd say even lawyers, they've got to prep for trial and stuff like that. So that's why people hire lawyers, because it is just such a complex field with all kinds of rules, regulations, and different kinds of things to try to remember and memorize. And people, they've got their other jobs that they're doing and things like that. That's why they hire lawyers specifically to do this, because it takes time. It requires so much expertise and knowledge and schooling and preparation to understand all the different nuances and things that are required to take that on. So thank you for speaking on that.
Well, yeah, and just one more thing.
Yeah, of
No,
course.
I completely agree because on one hand, without representation, a pro se tenant. On the landlord side, you've most likely got an attorney who does this for a living. Like you said, they've spent hours prepping for the potential of a trial. And on the
Right.
other hand, you've got somebody who's never been inside a courtroom before.
Yeah.
Um, you know, the odds are stacked in their against them.
Yeah. Yeah. Absolutely. So that could absolutely, I think, kind of create issues with you know, having, kind of like disparate impact, or kind of like a tipping of the scales, like one way kind of works towards someone else's favor. But again, those legal services are certainly available. And that's why I want to briefly just touch on LSNJ, because they coordinate the statewide legal service system in New Jersey, and it can be free if you qualify. So part of their mission is not only legal representation, but awareness about landlord-tenant law, which is why we are so happy to have them as part of our guests in this series as well. So we're going to have some members of the LSNJ office. So actually, it's Legal Services of Northwest Jersey. So I guess that's a subsect of or a section of Legal Services of New Jersey. Legal Services of Northwest Jersey, LSNWJ. They're going to be guests who are going to speak on some of the topics we have. So we're going to have David Saltzman's going to be joining us. I think he's one of the managing attorneys for their landlord-tenant division. We've got Randy Yang. We've got Jonathan Tolentino. So we're so thankful and grateful for them. They're going to be joining us as well and providing us with their legal expertise and talk on some of the subjects that we have coming up and some of that curriculum that we touched on in the previous slides. So again, and part of their mission again is making people aware of landlord tenant matters so that it becomes less litigious. But again, they are excellent representatives, legal counsel, zealous advocates for their clients, so compassionate, do such a great job, and such a great resource, and which is why that I am constantly emphasizing it, because for those of you who are unable to afford private counsel, Legal Services of New Jersey is an excellent resource. But again, please make sure that you are getting that help as early as possible, because I do want to make a point that your right to legal counsel is not constitutionally guaranteed in a civil trial. As it would be in a criminal trial, you are guaranteed the right to counsel. If you cannot afford one will be appointed to you. Rights that phrase we're all familiar with from the reading of the Miranda rights. That comes with a criminal trial. Civil trial, that's not the case. So legal services, it does depend on the availability that they have, the cases that they're currently working, the facts of your case. So again, the through line that I've been communicating to our viewers, our attendees, is that if you do find yourself in that situation where you are, going to go to trial, or if you get a notice to cease or a notice to quit and demand for possession of the property, or you're having issues with your landlord to begin with before it even gets to that stage, please call Legal Services. And you'll see on the slides up here, Legal Services of New Jersey. There's the different field offices from Sussex County to Warren County. Please call those offices and make sure that you do an intake assessment as soon as possible, so that they can take a look at your case and try to provide you with legal representation as early as possible. And if they can take your case, the earlier they can get in there and they can give you that comprehensive wraparound legal representation. So it's not just the same day, the same day that you're approaching them in court in the hallway and saying, I'm going to go into a settlement conference. What do you think I should do? And that's putting them in a tricky situation, because they don't know, every in and out of your case, and they don't have the time. And so they give exceptional, advice, but it's going to be more difficult for them to give you the best advice that they possibly could if they had time to sit down and really dig into your case. Okay. So that kind of actually brings me to my next question. Oh, but before I do get to that, I just want to say, if Legal Services of New Jersey is not an option, as you see there in the right column, if you're looking at our slides, we do have lawyer referral services as well. So if you want to call the Morris or Sussex County Bar Association, they should be able to connect you to legal, either low cost or what's called pro bono. So pro bono just means free, free legal representation. In most instances, Legal Services of Northwest Jersey or Legal Services of New Jersey, if you qualify, that is free legal counsel, or if it's at least on a sliding scale, is my understanding. So too, you can call lawyer referral services through your local county bar association. We're using the Morris Sussex County Bar Association as our example in this particular slide. Please call the number listed on the screen, 973-267-6089. And they can try to connect you with a free or low cost attorney to help represent you. And then, of course, if you cannot obtain counsel, you can always try to get consultation, either from the lawyer referral service or from Legal Services of New Jersey. In fact, Legal Services has a statewide toll-free legal hotline that you can call, and that is 1-888-LSNJ-LAW, or 1-888-576-5529. So that's 1-888-LSNJ-LAW, or 1-888-576-5529. Or you can go online at lsnjlawhotline.org. Or you've also got, for some of you who are living in buildings or you're living in complexes, there are tenant associations and groups, even perhaps at the county level, that can even connect you to programs, even like Family Promise of Sussex County. So again, the idea is early communication. So reach out to your landlord, reach out to your property manager. If you're struggling with rent, try to connect with a lawyer early, see if they can connect you with these programs. Because again, the earlier you intervene, the earlier you can compromise. You can try to make installment payments. You can try to negotiate, and you're going to have terms that are going to be a lot more favorable than if you went to trial. Because in my experience, the judge really doesn't have a whole lot of discretion when they get to trial. It's just, do you have the money or don't you have the money, basically. So the earlier you have an opportunity to intervene, the better it is, because you put your landlord on notice. They can work with you. You're making an attempt to try, and then you can get connected, hopefully, with services like Family Promise of Sussex County that could potentially pay your rental arrears, or you can get legal representation from Legal Services of New Jersey. That actually brings me to my next questions that I wanted to ask you, Chris. Um, what are so now we talked about a little bit about the disparity between defendants being represented by counsel and plaintiffs being represented by counsel. So you see in your experience, I think as you mentioned before, that defendants, they're most commonly represented by legal services.
Yeah, absolutely. Like we said, I mean, it's very difficult to find a private attorney if you're in that situation.
Yeah.
A vast majority of uh, tenant representation comes from legal services, or any other pro bono legal service, but it's certainly the most typical one we see.
Okay, excellent. And what's their presence like in the courtroom?
I don't know that a week has gone by, and again, I've been doing this for about 3 years now. I'm not sure a week has gone by where they haven't had attorneys present at our calendar call, which can be anywhere between 30 to 40 cases.
Wow.
Those are some of our heavier calendars, but
Wow.
we do go through quite a few cases weekly. And legal services has always had representation there. They'll even bring somebody to help with intake. Like you said,
Right.
there's
Right.
there's financial components to qualifying for their services. So they do have intake staff as well as the attorneys.
Mhm.
So they always have plenty of people for tenants to speak with.
That's great. That's great. Yeah, and in my experience in the courtroom as well, I'm not as there as often as you are, but when I have been there, I'm not as involved with CEDD in the courtroom sense, but I do have staff here that goes. But when I've been there, they are always there, and they are there. They roll deep. They've got at least 3, 4 attorneys that are there to help with the docket. And the judge, during her announcement, his or her announcement, lets the litigants know that if you need an attorney, they're right there, for you. Please get to them, and get to them early, before you go into your settlement conference, before you go into mediation, so they can try to give you some advice before you actually do that. Okay, and like you said, they have a particularly large caseload. Can you touch on that as opposed to a private attorney's caseload?
Yeah, I mean, usually the private attorneys have a set number of clients that they go into a court day expecting.
Mhm.
Sometimes they may still have quite a few cases. We see attorneys with upwards of 10 cases,
Yeah.
landlords attorneys on one day. But the thing with legal services is most of the time they walk into the courtroom having no idea the number of people that they're going to have
That's
to
incredible.
represent.
That's something.
Yeah, so they could be walking into a light day where we only have 10 or 15 cases, or like I said, they could be walking into a courtroom full of tenants, 30 or 40 deep, and almost every single one of them is asking to
Yeah.
consult with them. So their caseload is extremely heavy. I can
Yeah.
tell you that much.
Yeah. Busy day. Busy
And
day.
and that's not even including the tenants that call ahead of time and go through the intake process prior to court. So
That's
a lot
true.
of times they'll come in with 1 or 2 cases that they know about ahead of time, and
Right.
they'll leave with 5 or 6 extras.
Do they have to take every case that approaches them?
No, because like you said, I mean, there's no guarantee to representation in a civil trial. I don't want to speak too much about what their criteria is.
Sure. Sure.
They don't, they won't agree to represent everybody,
Mhm.
but I've never seen them refuse to
Right.
speak with a tenant who's
Right.
looking for
Right.
help. So at the very least, even if they are unable to represent you, whether it be the financial component, or maybe even just lack of defenses,
Right.
whatever the case may be, they can still at least give you advice on how to proceed.
Right. And I think, like you said, like they don't just turn them away like because like that's what they feel like. I mean, it's simply because either the caseload is too high or I mean, but like you said, they're always dedicated. They are the consummate professionals. I mean, they're always there to provide at least some form of advice, and they're very compassionate people, and they do a really excellent job. So that's really excellent insight on that. I really appreciate you filling us in on your experience in observing legal services and what they can do. And again, I can't speak highly enough about what they do. So just a quick aside, because we are talking about the expense of legal representation as a subject here in finding an attorney. Um, One thing I wanted to touch on real quick is speaking specifically to cost of an attorney, because I know some people do think, well, maybe because I don't want to deter anybody from approaching legal services. That is an absolute necessary service that is provided, and if you have to do it, you should absolutely 100% should pursue it. But for those of you who say, okay, well, maybe I have a family member or a friend that can lend me some money to get an attorney, or maybe I'm dissuaded because I've heard it's so expensive. So, just as a quick aside, there was a law that was passed in 2013, and if your lease was signed or renewed after February 1st of 2014, if your lease says that your landlord is allowed to recover attorney's fees from you if they win their case against you in court, the opposite is true for you. So just remember that if you do end up having some rather large expenditures for legal counsel to defend yourself in court, if you believe that if you can get to the trial level, if you believe that you have a defensible, a defense that's winnable and provable in court, and you take it to that level, then if the case is dismissed on the grounds of you proving your defense and you win, then your attorney's fees can be paid for by your landlord, just the opposite of what it says in the lease. So if your lease was signed and renewed after February 1st of 2014, if your lease then says that your landlord's attorney's fees are recoverable if they win their case against you, but if you end up winning, your fees can be paid by the landlord. So just again, just food for thought if you are considering expenditures for an attorney and your case ends up being winnable. That is something that you can think about, because there are certain defenses that we talked about in our eviction video. We talked about whether there were procedural deficiencies, constitutional deficiencies, anything that can be brought up to help dismiss your case, even if it's dismissed without prejudice, and the landlord can refile as soon as they correct those deficiencies. I mean, any win, gaining time at the property, or presenting mitigating factors to the court, I think is really highly important. But it kind of brings me to my next point, as we're talking about legal representation, when to have a lawyer, what free services are out there, or if you have to, pay for an attorney. One thing I wanted to ask you, in your expertise, Chris, and your experience in witnessing this during the course of your work at the courthouse, like what is the typical cost of legal representation that you see in landlord?
Right. So, I mean, like we talked about earlier before we started the video, it depends on the attorney and it depends on the client as well.
Yeah.
Like I said, we have landlords who, larger corporate landlords who may have 10 cases on any given day.
Right.
Typically, from what I've seen, those attorneys that represent every single one of those cases will charge some flat rate, but anywhere between like $200 to $500.
Yeah.
Yeah, and there are some hourly attorneys out there, generally speaking, and again, there's exceptions to this, so I'm not speaking in absolutes, but the smaller landlords that may just have one or two properties and may not need legal work as often.
Okay.
They might go with an attorney who's charging an hourly rate.
Okay.
It's just I'm sure there's business reasons behind that
Right.
that I probably wouldn't do a great job explaining.
Yeah.
But yeah, I mean, generally speaking, it could be anywhere between $200 and $500,
Sure.
maybe in excess if it's a particularly complicated case.
Yeah.
Maybe a holdover case where
Right.
something a little more complex than non-payment.
Okay.
Something that may get adjourned, or depending on how many hours they have to spend preparing,
Sure.
could be in excess of that. But generally speaking, yeah, somewhere around that $200 to $500.
So it's just important that if you are looking for a private attorney, that when you're navigating that field and looking for legal counsel, if that is your choice outside of legal services or anything like that, please just make sure that you check the boxes, or you take a look at what is best for you, what works for you, and works for your budget. But again, like we said, there's always legal services. There's a lawyer referral service. Really excellent programs that are available to you to provide comprehensive, low cost to free legal representation. But again, we caution you that that right to counsel that is guaranteed in a criminal trial is not guaranteed in a civil trial. So that's something to be aware of. So early intervention is very important. If you're going the route of legal services or lawyer referral service for any kind of pro bono or free legal representation, make sure you get in there early, because they have a lot of clients. As Chris had said, sometimes they might show up to court and they've got 40 cases on the docket, and people are approaching them. They're doing the best they can to provide legal advice, but in order to get that comprehensive, really in-depth legal advice, approach them early. And again, to make sure they can even take your case, you want to do an intake assessment with them early, and get that addressed as soon as possible. So that's what we had basically covered. And we talked about, just again, the costs, and again, if you're considering the cost and the expense of an attorney, you can have your attorney's fees paid if you win your case. If in your lease it says that your landlord can recover fees if they win their case against you, you also can get your fees paid if you happen to win that case. So that's something to remember. Just again, as a quick recap, and then of course, I think that pretty much wraps up what we were just kind of briefly discussing. And we of course talked about that. Even we were talked about that in landlord-tenant court. Judgment of possession is for the physical possession of the property. That especially in those instances where you have a defendant tenant who might be a public housing or subsidy recipient, they might not be responsible for those attorney's fees, even if it says it's recoverable in the lease for those fees. The law says that they cannot be evicted for not paying those attorney's fees. They're responsible for the base rent, but not those fees. But they could still be taken to court for those fees. They just can't be evicted for it. So attorney's fees, late fees, that landlord can have their attorney go to small claims court or district court and try to get those fees. They can garnish wages and things like that. So they're still responsible for it, but just know that you can't be evicted for it. So that was just a little aside that I wanted to discuss with you guys as a recap, in case you missed it, because it was a really great discussion that Chris and I were having. So very sorry if you did miss it, but that sometimes those technical difficulties do come up. And thank you, Jamie, for getting that corrected for us. So moving forward, talking about, now we're on to those tenant defendants who have to represent themselves, or what is called pro se. So pro se is just a fancy Latin, term, that is used in the law that just means that you're representing yourself. So those tenant defendants who are representing themselves, I wanted to ask you, Chris, what is kind of like the level of preparedness that you see from those kinds of litigants?
So that can kind of vary wildly, admittedly. A lot of times, like I said earlier, procedurally, they aren't quite sure how to go about navigating a landlord-tenant case. Some pro se litigants come in extremely prepared. They have all their paperwork in order. They know what arguments they want to make. They may have been through this before and just know what the process looks like. But I would say a majority of the pro se tenants that we see sometimes don't even know why they're there. Don't quite understand. They're not sure how much in back rent they owe. If it's for a holdover, they're not exactly sure what the notices mean. They're not sure why they're there. Again, it can vary wildly. I would say the more prepared tenants are fewer and far between.
Okay.
And again, that's not the fault of any tenant.
Right.
The legal world is extremely complex and difficult, even a summer proceeding like this. So it just depends, but excuse me.
That's okay.
Yeah, typically the tenants are less prepared.
And do you ever notice like language being like an issue there for like in terms of preparedness of someone who might not speak English as their primary language? Do you see that as an effect in that preparedness?
Absolutely, we see that all the time,
Okay.
and we do have the opportunity for tenants to request court-appointed interpreters
Okay.
for their cases. That may not help prior to court,
Right. Right.
but it can certainly help, especially when when they're talking to legal services, having an interpreter there.
Okay.
Um,
Right.
but it definitely can be an issue. I've seen it
For sure.
quite a few times.
Mhm. Yeah, and I yeah, in my experience too. But I will say the interpreters are incredibly helpful, and again, what an amazing job, and what a difficult job that is because it's really interesting to see when you're sitting in the courtroom and you're watching them. They literally will stand like feet away from the judge and they talk very quietly into a microphone, like while the judge is speaking, and they're capturing all the information, and they're the person they're providing that service to is sitting there, with a set of headphones on, so they can
Right.
hear and understand what's going on. So I'm glad that interpretive service is available to them, but I can certainly see how it affects their preparedness because even though they do receive, I think, their process in, like, for instance, their Spanish or other languages that it comes in. A lot of services that are provided sometimes aren't really, like you said, pre-litigation. It's hard to get those interpretive services.
Right.
Or if you have somebody here who is English is not their primary language, navigating the legal system can be particularly challenging.
Right.
And I think there's a lot of gimmicks and schemes out there that prey upon that lack of knowledges, like notarios in the Spanish speaking culture, in the Latino and Hispanic culture. There are people who will prey upon their lack of American jurisprudence and take advantage of that and claim that they're going to represent them legally. It's usually in like an immigration capacity,
Right.
but I can see it happening in landlord tenant as well.
Right.
All right. So moving forward with regards to representation of yourself in court, one of the things that I think is really important for our viewers are to understand and know. So as you'll see on the slides here, folks, reading all the court papers, reading all of your legal papers, don't miss your court date, understanding everything that you have available to you. But one thing that I want to touch on that's not in the slides that I think is a really important point is about, as we talk about when is it important to find a lawyer and obtaining legal services and things like that. One of the things that I think is a really important point to touch on is understanding legal process and the procedure. And we talked about how complex it is, not just the substantive letter of the law, but the procedural law as well. Because I think even sometimes knowing procedure, it trumps substantive law. But knowing your rights and knowing the process and knowing these things is going to be really important for you. And again, this isn't a law school seminar, so we can't get too deep in the weeds about case law and things like that, and tactics and tools. And we certainly can't give advice. But I think one of the most important things that defendant tenants are going to come across in their experience when they receive their summons and their complaint is the Harris announcement. And that's something that I wanted to cover with you really quick. So when they receive their legal eviction process, some of what they're going to get is going to be the notice to cease, which we talked about is, please stop this behavior or you're going to get evicted. But if you stop, we won't evict you. The notice to quit and demand for possession, as we talked about in our eviction video, is, we've asked you to stop. You didn't stop. Now we want you out by this date. Here are the dates that we're referring to, the instances, the times, the dates, the specific instances this happened. Here's the law that we're referring to have you removed. And you need to be out by this certain date. And they're asking you now that you don't have to leave at that time. You can. The only time you actually physically are compelled to be removed from the property is when a warrant of removal is executed and a special civil court officer is actually there to remove you. So, but that is another topic. I don't want to delve too specifically into that, but just as a quick aside, that nobody can actually physically remove you from that property unless they are authorized by the court as a special civil part officer. But your determination as to when to leave, that is something that will, I think, be determined or should be determined by you, your family, your legal counsel. That's again why it's so important to have that early intervention to make sure that you are apprised of your rights and you can make those calculated decisions and say, do I want to go through a lengthy eviction and risk a negative or adverse credit, because of this, or a bad tenant score? If it ends up being if my landlord ends up winning and if I end up getting evicted and things like that, or can we negotiate a settlement like a pay and leave or no pay and leave agreement, a settlement stipulation whereby they can leave and there's no effect, there's no adverse credit reporting, they don't have judgment of possession entered against them. So there's all kinds of decisions you can make, but again, it is so important to try to get legal representation to guide you. But if you don't have that, what we're talking about is knowing, these processes and knowing what's on there. So I think a really helpful tool that after you get those notices and it's now at the litigation stage, when you receive like a complaint and a summons that says you have to be in court, here's why you're being evicted, and all that information that comes along with your tenant's rights, is something that came out of some case law, New Jersey Supreme Court ruling, referred to as Community Realty Management v. Harris. Something really important came out of that case. Chris, I would love for you to touch on that. Can you tell us a little bit about what came out of that?
Sure. So it's essentially, in the Harris announcements will be available to tenants minimum of 3 times before their court date. Like you said, it will be served with the complaint summons. We play the video at the beginning of every court session, and then the judge will then recap the video.
Yeah.
So minimum 3 times, and a lot of people either don't read or kind of snooze through the video, which I get. It's not exactly Game of Thrones from an entertainment perspective,
right?
But it is extremely important information, and it gives tenants, especially those who have never been through this process, a very good overview of what exactly their rights are and what the process looks like.
Yeah.
And again, it's not supposed to take the place of legal advice. The announcements aren't going to tell you what you should or shouldn't do. But they do make you aware of exactly what your rights are.
Right.
Illegal lockouts are something that get brought up in the Harris announcements.
Sure.
Like you said, only a special civil part officer has the right to perform a lockout. Gives you information on post-judgment relief. So even if you've essentially lost your case, you have a judgment of possession against you, there are still avenues for relief.
Yeah.
And even before that, it just gives you a very good idea of what exactly your rights are as you move into the mediation process. And if that's unsuccessful, then to trial.
Right. Right. Okay. Excellent. So let's see. Now, as we move forward, we did have a presentation. So one of the things that I wanted to talk about, and we'll just touch on it briefly here, is we do have, as you can see in the slides, folks, accessing and using the e-court system, which is a really exceptional and really great tool to use if you are a litigant. It's a great way to access your information, access your case jacket virtually. So even if you're served with your complaint and summons, it's got your docket number on there. It identifies when you have to go to court. Has lots of really important information. But let's say you call and you request an adjournment, or you work out a deal, or some motions have been filed and there's been some postponements, or there's been some complexities to the case that throw the dates off, and you need to keep track of this information. Let's say you lose that information. E-courts is a really excellent system, and these cases, landlord-tenant cases, they're a matter of public record, so they're easily accessible through the web. And we have a presentation that talks about the e-court system and how to register an account and how to use that account to access your case jacket and get updated information, correspondence with the attorney, the courts, any rulings that come down from the judge, things like that, important dates, postponements, information that is really valuable. So unfortunately, we're getting a little crunched on time. We did have some technical difficulties. I apologize for that. But what we're going to do, this video, is we're going to make that accessible. We're going to post it online as a separate obtainable informational document and video that I recorded. And again, it's me recording, me browsing and showing you how to register. You go into the website, registering an account, and then operating and actually using eCourts and how you can identify that information. But we're not going to go into that today because it is a length. It's not incredibly lengthy, but it's about 26 minutes. And I want to respect Chris's time. It is, we're only scheduled till about 7. We might run a little over if we jump into a Q&A. And again, I just want to make sure, again, make folks aware that it is out there, it is available. We will post it to our social media and make it accessible to everybody. And that is coming forward. It's going to be posted as soon as possible. So do want to apologize that we're gonna move forward at this time, but just let you know that it is out there, and we're gonna work very hard to get it available to you as soon as possible. So as we move forward, I want to, let's just go ahead and move forward to our next slide. I'm going to put this in presentation mode. That makes sense. Oops, we're skipping forward. So we did eCourts. Might be a little bit of a delay. So let's go back. I think I hit the right button now. Maybe give it a second to catch up. Oh, and another reason why we didn't actually play the video for you today is because there's no sound on the live stream. So I think that's probably the most logical reason why we're not viewing the video today, is that there is no sound for you to enjoy the video. So you're not going to really gain a whole lot from it if you can't hear me. So again, we'll work those kinks out and we'll have that available for you. So again, what we want to do as we kind of round out this discussion, we just want to briefly touch on some services that are available to you. So again, if you are representing yourself pro se or for yourself, we want to make sure that you have those tools available to you. So law libraries are an excellent resource for researching the law. If you find yourself in the position where you want to dig in yourself, find the case law, find the statutes, find the regulations, find all of that information that can help put on a defense for you. That information is available out there, and it can be found at law libraries. Now, there are, to my knowledge, 2 law libraries. We have the one up there, the State Law Library, which is in Trenton, and that address information is available right there for you. So please, take advantage of that. And the law libraries are great. So just don't think that you're just going to go to a law library and then just be lost in the stacks. And it's going to be dusty piles of books that you'll never be able to make any heads or tails of. No, in fact, there are librarians there who have Juris Doctorates, they have JDs, they graduated from law school, and they are experts at case and print research. And they will walk you through and show you how to research your case. They will help pull the applicable, laws and statutes, and they might have access to even virtual online databases like LexisNexis and Westlaw. Some really great, powerful tools that can help you mount a defense and really organize and prepare your case. So please take advantage of that. And you can always call these libraries as well. I don't know if it's possible, but perhaps they can collect your email information and send you information, or if you reserve books, maybe you can go down and pick them up. I'm not quite sure how that works, but again, that information, that resource is available to you, and please call that number if you have that. One that's not on there is the Rutgers Law Library. So for those of you who are located in northern New Jersey, who need this information, and Trenton is a bit of a hike. The Rutgers Law Library, the Newark campus, is 123 Washington Street in Newark, New Jersey, 07102. If you want to put that in your GPS, or just simply Google Rutgers Law Library, and it is at 123 Washington Street there in Newark. Their number is 973-353-5677. That's 973-353-5677. Then, of course, you also have your local library. So if you don't have home internet, so if you do have home internet, great. If you don't go, you can go to your local library and use their internet terminals as well. Google is a great way to start if you don't actually have access to the law library, if you're not close, if driving or commuting there is difficult. Your local library is a great start. Use Google. If you're at home, use Google. Just make sure, if you type into their search engine, the keywords that are applicable to your case, anything that you come across, just make sure that it is, applicable, binding New Jersey law. You don't want to start, citing cases that are in, New York or any other states. You want to make sure you use New Jersey law, and make sure that they're not out of date either. Make sure that they are updated cases. But again, we're just giving you a general guidelines to kind of help get your start. We could go hours and hours and spend about case and print research and how to properly look up law and talk about specific case law. I wish we had more time to talk about those things, but unfortunately, we just don't have the time to do so. But we can get into those specifics during the Q&A if you have any questions about that. That would be really great. But we'll make sure we try to address any of those things. One thing too that is really helpful is the New Jersey State Library also has great information for pro se litigants. So you can visit that at njstatelib.org /author/Clambert. So that is njstatelib.org /author/Clambert M as in Michael, BERT. So that is their website if you want to use the state law library. They have a really great rundown of from top to bottom of how to research your case, and to how to look up, case law, how to look up statutes and regulations. So, and just to kind of give you a quick overview as to what those are, you hear these words. So a statute is a proposed law or a bill passed by the legislature, signed by the governor, and that becomes law. You also are going to hear about regulations. So some statutes require state government agencies like the DCA to adopt certain laws. You've got case law. So these are laws that are made by judges when they decide cases. And then you've got local ordinances, which are city or township or municipal or borough level kind of laws or regulations. Then you've got federal laws that govern like subsidies or public housing and things like that. So just kind of a brief overview of some of the terms that you'll hear when you do your research. But again, please refer to the resources that are there. So law librarians and librarians in general that can help you look up statutes, who can help you look up regulations, who can help you look up case law. These are all things that can help you research your case. And again, unfortunately, we don't have the time to go into every nuance about that. That's taught in a semester at law school. So unfortunately, we won't be able to cover that in a seminar this evening. But we wanted to just kind of let you know what kind of language is out there. And you'll see in this statute right here that's what you'll see. And these are the different kinds of rules. These are the different kinds of things that you will see that might be applicable to your case. So you might find a law that's been a statute. I might find a law that's been passed by the state legislature that controls what's going on in your case. And you might want to cite that if and when you go to trial, or if you're going to settle, you might say, hey, that my landlord was in violation of this rule, and this is in this statute here. And of course, the law libraries can help you find those statutes. Or you've got the regulations here that you can find as well. There's case law. So that, again, like we said, those are decisions that have been made in other cases by judges. And that's where you can find certain rules interpreting those cases as well. And then local ordinances, and then we've got the federal law as well. Local ordinances, again, are at the municipal level, and then federal law, more applicable to, in this case, we're talking about public housing or federal subsidized housing, okay? Not so much landlord-tenant laws. That's largely, I think, kind of governed by like state law, right? So that kind of rounds out, our visual presentation. We've got a nice quote there: "Home is not where you live, but where they understand you." That's really lovely, and that I think, wraps it up nicely about what your home is and how important it is to guard your rights and stay where you are, and try your best to stay where you are. Work it out where you are, because, like you said, as cliched as it is, home it's not just where you live. There's memories there. It's so important. It's part of who you are. So make sure that you exercise those rights, assert those rights, know what they are, and in the event that you find yourself in litigation, please make sure that you take advantage of the resources that are available to you. So as we close out our presentation for you folks this evening with Mr. Whitten, I just want to just ask you kind of quickly as we wrap up here, just going to fire off some questions for you. And,
Sure.
and if you don't mind giving me just a little bit more of your time, what are the most common, like as we talk about citing case law and citing statutes and, researching and using these resources to present a case, what in your experience as a court officer in landlord-tenant law, what did you most commonly see as defenses that were raised by defendant tenants?
So, I mean, most of the defenses are procedural in nature, meaning
Yeah.
maybe the landlord didn't properly file the case, didn't include a
Gotcha.
certification or registration statement from their municipality.
Right.
Because again, most of our cases are non-payment of rent. I would say
Right.
80 to 90% probably are non-payment of rent, and
Wow.
really the only defense for non-payment of rent case is paying
Paying
the
rent.
money. Right.
Yeah.
So we do see some Marini defenses or habitability defenses.
Okay.
Those are
What's that?
rather so. Marini defense is a habitability defense. It's basically asserting that you withheld rent from the landlord due to the living unit being unlivable.
Okay. So like a place that's like when you say habitability, you mean like place that's not meant for, or that is like uninhabitable, like it's like
Correct.
it like poses a safety issue or something, or like a health issue.
Exactly.
Okay.
So if the roof's caving in, if there's black mold all over the unit,
Gotcha. Okay.
but there's several steps that the tenant has to take before they can assert that defense.
Okay.
One, they have to have put the landlord on notice of the deficiencies in the unit and
Okay.
given them an opportunity to remedy that.
Okay.
They also have to have all the rent available that they're withholding.
Okay.
Typically, they would have to deposit that with the court in order to schedule a Marini hearing,
Okay.
which is basically a habitability trial.
Oh, so it's like its own separate thing.
Yeah, it's still done under the landlord-tenant docket. You wouldn't get a new docket number; it would still be the same case.
I got you.
Just a slightly different kind of hearing. I mean, most landlord-tenant trials only take 15, 20 minutes,
Okay.
if that. Marini hearing can be a little bit longer because you'll have exhibits, pictures, whatever
Right.
the case may
That
be.
makes sense.
Most likely some sort of testimony.
Okay.
So it's just a little bit more involved
Okay.
than a typical
gotcha.
landlord-tenant trial would be. So yeah, there are some hurdles that a tenant would have to jump over before they were able to assert that defense.
So that makes sense because I've had, like in my experience in the resource navigator world, when we would come and see if we could help people with paying their back rent, stuff like that, we would come across people who would say, in response to an eviction, they would say, "Oh, the reason I didn't pay my rent, Judge, is because this place is squalid or this place is unlivable, or there's all these issues I asked the landlord to fix and they never fixed them, and that's why he or she hasn't gotten paid." But now I understand why, because I'm always like, well, isn't that a legitimate reason? But there's a whole process to it, is what you're saying. So they need to, before they even get to court, like way back, they need to have put the landlord on notice that, hey, we're not going to pay you rent until you fix this.
Exactly.
And then and then they have to, and then I've heard something about like does it have to go with the court? They have to put the money with the court at that time?
Yes, typically the judge would have to issue an order,
Okay.
allowing the tenant to deposit those funds into escrow with the
Gotcha.
court.
Okay.
And then obviously the court would hold those funds pending the outcome of the case.
When they do that though, when they deposit that money with the court, and the court is basically allowing them the money that would have gone towards rent goes into this escrow account, does the landlord have any rights then? Like, can the landlord come after the tenant at that time and say, well, I deserve this money? Like, can they raise any kind of claim at that time?
Not at that time.
Okay.
Which is kind of the point of putting it in escrow with the court. I mean, if the landlord has any separate, small claims or DC matter for the money at that point, that would all essentially be cleared up anyway.
I got you.
If the tenant does not prevail and the funds are released to the landlord.
I got you. Okay, so that's why the court asked for you to put it there, so that if so you're saying that in the event that the defendant doesn't the tenant doesn't prove their case, that money it's like no harm, no foul. Here's the money for you that would have Okay,
Exactly.
I
Yeah,
got you.
because your whole argument isn't that you're not paying rent because you don't have the money.
Right.
It's that the landlord wasn't holding up their end of the bargain.
Okay.
The other thing I'll add really quick about the Marini hearings is it does have to be it has to be a material defect, meaning the examples that we gave, the roof's caving in,
Right.
there's black mold everywhere, there's no heat in the winter,
I got you.
that sort of thing. It can't just be a leaky faucet.
Okay.
Right? It has to be something that materially affects the livability of the
Okay. That's really okay. Thank you for clarifying that.
Mhm.
Because again, that's something that we see here at Family Promise. Like when in our CEDD program, when we're at court, that is something we will commonly see in response to a non-payment of rent, like eviction lawsuit.
Right.
They're getting evicted, and they said, "Oh yeah, well, this is the living conditions that we're subject to, and that's why we didn't pay our rent." But now I'm seeing that it seems like it's rather complex.
It is, and typically an attorney would be involved
Mhm.
with a Marini defense if it gets to that stage.
Mhm.
Just simply for the fact that I don't think most pro se tenants are aware of the noticing aspects of it. So
Right.
you never gave written notice to the landlord. It's difficult to raise that defense,
Right.
and most people don't know to do that unless they've consulted an attorney.
Right. Yeah. And then of course the court will ask you to post bond
Yeah,
with the
essentially.
court. Okay, I got you. Okay, very good. So just a couple more questions, and as we round this out and we finish up the curriculum for this particular course, I just wanted to ask you about your knowledge of the clerk's office. So for those pro se litigants, or those especially those tenant defendants out there who need all the resources they can get to help the strength of their case, or for any tools like you had mentioned before, that there is, even if a judgment of possession is entered against a tenant, or a warrant of removal, that final stage that says your case is you've lost your case, you're at the final stage, you're about to be removed. I still there are still some tools, like you said, there's still some relief for that tenant, and I think they can get them through the clerk's office.
Correct.
Can you talk about a couple things, like specifically? There's three that I think are referenced in that Harris announcement that we talked about. There's the order for orderly removal. There's the order to show cause, and then the hardship stay. Can you just elaborate on that?
Yeah, so I mean, they're all three slightly different. For orderly removal, it's essentially a one-time 7-day extension of the lockout date.
Sure.
So once the warrant is issued, and you really can't file for orderly removal until the warrant is issued, because there has to be a lockout date in order to get that 7-day extension, right? So for any articulable reason, essentially, it's at the judge's discretion to grant those extra 7 days.
Okay.
The order to show cause, and typically we'll see them both filed at the same time. In case the order to show cause is denied, then orderly removal is the next option, right?
Right.
So an order to show cause is a little more complex. There may be some defense that wasn't raised at trial. Maybe the tenant came up with the money and the landlord's refusing to accept the payment.
Right.
Whatever the case may be, if there's something a little more substantive that you think could materially change the outcome of the case, that's what the order to show cause is for.
I
Right?
got you.
So it's asking for more than the 7 days. It's asking possibly to reopen the case or reconsider.
Gotcha.
The judge's final decision.
Yeah.
The hardship stay, in 3 years I haven't seen one of these.
Okay.
It's an extremely high bar to meet. So obviously you have a judgment of possession against you if you're filing for this.
Okay.
Like the Marini hearing, you need to have all the money available that's owed.
Okay.
So if you were evicted for a non-payment rent case, that's going to be difficult to do.
Right.
And my understanding, and again, I've never actually seen one of these, but my understanding is that it, for lack of a better term, is basically a deathbed type situation.
Right. Oh, wow. Okay. That high.
Yeah, and there also can't be any available housing for you to move into, and that the law doesn't state affordable housing; it just says housing.
Wow. Okay.
So again, it's an
So
extremely
yeah.
high bar to meet. People kind of conflate all three of them sometimes, but
Yeah.
the hardship stay is kind of the outlier.
Right.
The order to show cause and orderly removal are kind of go hand in hand.
I can see that. Yeah.
Yeah, but the hardship stay is very, very difficult.
Okay. And what's like the max? You might have mentioned what's the max amount of time you can stay with the hardship stay?
I believe it's 6 months.
Okay. I thought I heard that too.
Yeah, don't quote me on that. I believe it says in the Harrison announcement 6 months, but yeah, again, having never seen
Right,
it,
right.
it doesn't stick in my mind.
Okay. All right. But like you said, back to your, reference to the order for orderly removal, or excuse me, the order to show cause, or actually even back to the order for orderly removal. One thing I noticed, or what we advise, now we don't give legal advice, but what I've heard, what lawyers will do with tenants, or what they have said, is that wait, if like, especially if they have a warrant of removal, you wait until like the day before the WOR is supposed to be executed. So you are essentially extending as much time as you can at the premises.
Yeah, I mean that could be one strategy. It's usually calculated just based off whatever date is set on the warrant of removal,
Gotcha.
right? Because when it's posted, it'll have the exact date
Right.
the lockout's going to happen. So whether you file it, and those, depending on the court officer's schedule, it could be a week out. When it's posted, it could be 3 days.
Gotcha.
There's some wiggle room. So really, it shouldn't theoretically matter if you file it the day the warrant's posted or the day before lockout. It's typically calculated off the end of,
Oh, okay.
of whatever date is on the warrant.
Okay, very cool. And yeah, and we've even seen some of those order to show causes in some of my work with the attorneys at legal services. I've seen them when they've worked with clients like you said, typically like you've seen here at Family Promise, we deal largely with non-payment of rent cases. And if it's just a non-payment of rent case, my understanding is that if the tenant defendant has all that's due and owing, either themselves or through like a nonprofit charitable organization like Family Promise, that the landlord is compelled, they have to accept that money. And then I think I've seen it where maybe the landlord isn't as well versed in the law, doesn't know the law, and then the attorney at legal services will say, okay, well, we're going to file an order to show cause, get this in front of the judge, so that we have an official ruling that says you have to take this money. Is that kind of a good example of like how that tool is used?
Yeah, that's a great example because, like I said, it's something that would materially change the outcome of the case.
Right. Okay, that's a great phrase. Materially change.
Right.
Okay, gotcha.
Yeah.
Okay.
So yeah, in that case, and we see that with pro se landlords.
Okay.
Typically, if it's a represented landlord, they kind of understand that they have to accept that money.
Right.
But some pro se landlords just don't know that. Because not all of them do their research before they decide to become landlords. Nothing against them.
Exactly.
I understand it.
I get it. Yeah.
Yeah, it's
complex.
Complex.
It is.
But yeah, some people don't realize that that's a thing. They have to accept the rent money, especially if that's the sole reason for the eviction proceeding.
Okay. All right. Well, good to know. And final question that we have here, as we will just conclude this here. What has your experience like with nonprofits in the courtroom? So, that's how we came to know each other. Our program, we have that grant, comprehensive eviction defense and diversion, that comes from the Department of Community Affairs, and it allows Family Promise to go to the courtroom in Sussex and Morris County and help solve the problem, whether it's pay the arrears that are owed, or it's help with relocation of a client, or if we have to find other alternative resolutions to the conflict, meaning if there's substance abuse in the household or mental health crises that have contributed to the non-payment of rent. We can help identify those needs, and we can plug the client into the area services. So it's bridging the gap between the courtroom proceedings and the area services to help find funding streams that can help resolve their needs, or help provide them with the services that help patch those needs up.
Right.
What are your observations of that? Like, how has that been since you've been in the courtroom as a staffer? What has your observations been? What's that like for, and not just Family Promise, but I know Catholic Charities has also had a courtroom presence from time to time. Do you invite do you invite these agencies to come? Like, do they reach out to you and request to be present? How effective have they been in helping resolve conflicts and working with attorneys and court staff? Can you just kind of expand on that a little bit?
Yeah, absolutely. I think all those programs that you talked about, yours in particular, legal services, community connection,
Hmm.
any number of the organizations that have had a presence in the courtroom have been fantastic.
Great.
Selfishly, they take a lot of pressure off court staff because you end up getting a lot of the questions that you should be getting, but
Right.
we usually get,
Right,
but we
right.
can't answer. So that's very helpful for us. But no, your lines are always extremely long. There's a
Yeah.
reason people want to talk to you,
Right.
and it's because they're receiving the help that they need from you.
Yeah.
So I think it's had a great impact. And obviously, at the end of the day, so it's helping the landlords as well.
Right. Right.
They have to spend less time in court. That believe it or not, they don't want to be filing these lawsuits either if they don't have to.
Right.
So having those resources out there to avoid litigation, avoid coming back to court time and time again, I think it really helps everybody.
Yeah.
And
Sure.
I think it's extremely valuable, and I'm very grateful that all these organizations have had a presence in our court.
Thank you. Appreciate that. Well, and we are grateful to have had you as a guest this evening. Again, I really just the most sincerest gratitude and thanks and appreciation for your time this evening. I know we even ran a little over, but really just so happy and so proud that our program is able to have a guest like you here. We're super excited to have you be a part of that, as well as our other guests. But someone from the court, someone, and you had to get permission to be here too. So it makes us feel so good, especially with that last question, um, because it's so nice to be able to operate programs like that. You need the cooperation of court staff, and you need to be able to go in there unfettered, and it's your territory, it's your turf, it's your house, and to be able to accommodate us. You guys are always giving us conference rooms. You're always, even let us sit in the jury box with the attorneys. It's been just such a lovely experience, and working together like that has allowed us to serve the clients in that streamlined fashion. And it's been really great. So from that, and for you to take the time out here and speak to our guests, or speak to our attendees and our viewers, and allow us to put this content out there for people to enjoy and learn information about, is extremely valuable. And again, really, thank you very much for being here this evening, Chris. Appreciate that. Yeah, absolutely. So that concludes our presentation for this evening. I hope you enjoyed listening to it and watching it as much as we enjoyed presenting it to you. And really, just been a lovely experience all around. And I want to just let you guys know we've got course 3 coming up next Tuesday. And that is going to be renting your new home and understanding your lease. So that is going to be a whole lot of fun. And we are looking forward to that, and having you there. So please, and that's going to be September 24th. So again, renting your new home and understanding your lease. I don't believe we have a guest slated for that spot, but either way, it's going to be a really great discussion. Then we'll be, October 1st, I believe Sarah Webb from Community Health Law Project is going to be joining us. So that'll be another really great discussion, a lot of great information to learn. And again, thank you, Chris, for your time. Thank you for joining us. We look forward to seeing you next time. Had a lot of fun. So thanks a lot, people. Have a great night. Bye. Information about what he sees in the courtroom, and that there are